Hello and welcome to the Vercammen Lawful Legal Podcast. This edition we look at community caretaking and DWI. The name of the case is State versus Wancura-Lava, Wancura-Lava. Here the DWI was affirmed based upon community caretaking. So the defendant had appealed her conviction for DWI. Here the night manager of a store called police because a patron looked like she had been assaulted and was sitting in her car in the parking lot. Police responded to do what's called a welfare check. The car was pulling out of the parking lot when the officers arrived. Officers saw the driver was visibly upset and looked as if she was crying. The officers stopped the car to check on the driver's condition, not looking for someone with a DWI. The officers, though, eventually determined the driver was under the influence. The defendant conditionally pled guilty and appealed her denial of her motion to suppress, arguing that the motor vehicle stop was unlawful. The state argued that the stop was justified under the community caretaking function of law enforcement, and they didn't need probable cause to show that there was any type of traffic violation. The court agreed the officer had a reasonable objective basis to believe the driver was in need of help and posed a risk to herself and others by reason of her physical condition. The store manager had observed her to be unsteady on her feet and believed she had been beaten, and the officer's observations were consistent with the manager's information. And that's State versus Wancura-Lava. For other information on DWI and defense to criminal and traffic charges, visit website njlaws.com. And for representation, contact Ken Vercammen's office in Edison at 732-572-0500.